Sir Anthony Colman and Charles Kaplan asked to speak about arbitration proceedings in France and England. It's in 30 minutes, so it's quite impossible. So they agree to give some explanation only to three salient features of the French proceeding in international arbitration, and that is Charles Kaplan, and then Sir Anthony Colman, who is so well known that there is no need to introduce him, will react and give us the English point of view about these French peculiarities. So I don't want to take too much time. I am only a moderator, that means not a speaker. And so, Charles Kaplan, you can begin.
Thank you, Mr. Secretary General. Why are we talking about French law? Obviously, you may think this is a completely obvious point. Most AFA arbitrations take place in France, but they don't have to. And very recently, we got a case in where, although there was some confusion as to how the clause was drafted, actually, one of the possible seats was Tokyo. Nonetheless, it remains the case that at the moment, a great majority of the AFA's French caseload will involve arbitrations with French seats, and to that extent, obviously, if we are encouraging use of the AFA rules, then pointing out some of the particular features of French arbitration law is indeed pertinent. I've picked three, one which I will call before, the other one the second I will call during, and the third one I'll call after. Before, what is the effect of an arbitration clause? And note, I don't say a valid arbitration clause, I say an arbitration clause. You're all familiar with the principle of competence, namely the concept that arbitrators can, at least at a first stage, rule on their own jurisdiction. And of course, that's now been incorporated since 1996 into the statutory law of England. In France, this principle is absolute. In other words, it is presumed that the arbitrators at the first stage have jurisdiction, and this is presumed irrespective of how precisely we interpret or parse or basically examine the entrails of the arbitration clause, as has sometimes been the tendency of English courts. French courts have foregone that a long time ago. And they've even gone further, and this is my second point. No, sorry, we're still on the same slide, second bullet. That's right. There's a reverse side of the coin. If arbitrators have jurisdiction to rule on their own jurisdiction, then it follows that courts don't, at a first stage, at all. If the relevant provision originally was a domestic law provision, Article 1458 of our Code, Civil Procedure, which provided that where a court was seized of an action and a party raised the existence of an arbitration clause, the court must decline jurisdiction unless the clause is manifestly inapplicable. So you see, the boot is entirely on the other foot. Manifest inapplicability, manifestly void, Manifestly void means there's no argument about validity. It's obvious. You cannot even seriously debate the point. It is so clear the clause is void. If you don't reach that standard, then the issue whether the clause is valid or not is for the arbitrators to decide. And that is the so-called negative effect of the competence principle, which is fully applied in France. Now, we take it one step further. I mentioned that Article 1458 is actually in the domestic part of our law, and our law is divided into two parts, the domestic part and the international part. The international part actually doesn't say anything about this whatsoever, but obviously, in the logic of arbitration law and favoring arbitration, the rule went even further. in international arbitration to begin with. And it was a judge-made rule. They started with Article 1458, and they said that in international cases, it is a matter of principle that arbitrators have the first right to rule on their own jurisdiction. Now, you'll have noticed there is a gap, because we've only talked about validity. And you know, what if there is an arbitration clause, only it just happens to be completely irrelevant because it's in another transaction, another contract, or between even different parties other than those who are before the court. So the rule was perfected, originally stated in a leading case called American Bureau of Shipping. It was then perfected in a case you may have heard of called Quarto Children's Books, which then said, well, in addition, there is an exception if the clause clearly, manifestly is inapplicable as well, and that is a purely judge-made provision. And the law now is stable. The principle is firmly established. Let me give you examples which may seem shocking or surprising to you. But for instance, if a contract contains inconsistent clauses, an arbitration clause and a jurisdiction clause, well, that does not pass the manifest nullity or the manifest inapplicability test. The arbitrators are going to have to figure that one out. That's been decided. In that case, again, looking at the logic of the French legal analysis, it seems fairly obvious that you're going to give arbitrators precedence in order to decide jurisdiction rather than courts, and therefore you are following in the same logic if you in effect decide that at a first stage you're going to give priority to the jurisdiction issue under the arbitration clause rather than under the jurisdiction clause. How about, though, if you have two arbitration clauses or references to two sets of rules? There is a decided case. Parties put a reference to the AFA and the ICC in their clause. Now there, in addition, you have the problem of which arbitrator is going to be given the tough job of deciding whether or not he has jurisdiction. Well, again, the attitude of the French courts is, you'll work that out later or yourselves, but at this point, that's not for us. So that passes the test as well. Now, of course, there are exceptions. Manifest inapplicability, I'll only deal with one to show that the rule is not completely unreasonable, as you might be led to think. In a transport situation, international contract of carriage, a booking note contains a reference to arbitration, but the contract, as subsequently concluded and confirmed, does not. There the court was able to say the evidence is absolutely clear that there was a meeting of minds on the contract of carriage itself, which does not include any reference to arbitration. There's no argument, there's no discussion, it's completely clear. This clause is manifestly inapplicable. So you do have exceptions to the principle, but the starting point is that court jurisdiction and arbitration jurisdiction very much do not play on an even field in France. The bias in favor of arbitral jurisdiction is very strong. Now, of course, I said at the first stage, because at a subsequent stage, if an award is submitted to a court for review in an application to set aside, then obviously the court will actually look at jurisdiction in somewhat more depth than a manifest nullity or manifest inapplicability test. So that's a feature of French arbitration before. French arbitration law during the course of the arbitration procedure. If you look in our code and look for rules or guidelines as to what arbitrators should do in terms of how proceedings should be conducted, I mean, along the lines of what you do find in the 96 Act, although the 96 Act is mostly permissive rather than prescriptive, actually, if you look in the French law, you won't find anything. All you will find is that, Article 1494. If the arbitration procedure is determined in the parties' agreement, either directly, what I mean by directly is there's no reference to any law, to any set of rules. The parties provide procedural rules in their agreement. In practice, as we all know, this is very, very unusual and would probably not be best practice for people drafting arbitration clauses today. But that was considered a possibility when this code provision was enacted. Secondly, they can refer to arbitration rules in order to define the procedure to be followed. Thirdly, they can refer or decide to apply a procedural law. I mean, will apply the CPR, will apply the Code de Procédure Civile. In practice, people don't do that often, and I wouldn't advise them to do it, whether in France or anywhere else. And then, failing the parties' agreement, the arbitrator is in effect in the same position. He has the job to determine the rules, without reference to any law, any procedural law, or any set of arbitration rules. He is completely free. Secondly, by reference to arbitration rules, or thirdly, by applying a particular procedural law. But in practice, in a majority of cases, international arbitrators sitting in France, to the extent that arbitration rules don't apply already by virtue of the parties' agreement, would not, in most cases, in hardly any cases, would they refer to a set of national procedural rules as being the rules they are going to follow in their arbitration. There simply is no point. Secondly, arguably, all you're doing is creating a potential nest of problems if anyone later on wants to argue that you didn't apply whatever the national procedural rules were properly, and they want to hang an application to set aside on that particular hook. You shouldn't leave any hooks sticking out, so you don't do that. And the drafters of the French rules have given arbitrators a completely clear field, and that is indeed the dominant practice in Paris and in France. Second point, that was procedural law. The position with substantive law is largely the same. If you go to the next. If the parties have chosen rules of law, note the expression rules of law, not a proper law or an applicable law. Rules of law covers anything which can be identified as a set of rules, a national system of law, a transnational system of rules. If you want to run your arbitration under substantive points under UNIDROIT principles, you can do so. If you want to refer to the much maligned lex mercatoria, the general principles of international commercial law, you can do so, although obviously there is some woolliness there as to what exactly the content of lex mercatoria is. But again, the principle is complete freedom. And note, absent such choice, the dispute is determined in accordance with the rules the arbitrator considers appropriate. Another point there, no reference to the arbitrator going through any system of conflicts. Arbitrators sitting in France don't have to apply any particular law, except if it's been chosen by the parties, and they certainly don't have to apply any particular conflict of law system. They can, so long as they justify their decision rationally, although again this won't be controlled as such in most cases, they can use whatever method they feel is most appropriate in order to choose a law or a system of rules. Now, the last reference, which is the arbitrator shall take trade usages into account in all cases, there is some controversy about this. I mean, trade usages, in the narrow sense, is the same as in English law. If there is a custom in a particular trade or profession which can be proven, it can mean that. It's also been argued, though, that it means the usages and customs of commerce in a more general sense. Here we're floating back towards these ideas of general principles of commercial law. At the very least, it suggests that arbitrators may not have to apply. Suppose the parties have chosen some particular law and there's some particular strange formalistic rule that contract isn't valid unless you stand on your left leg and cross your fingers behind your back when you sign it. International arbitrators may feel that they want to moderate or find some way of not applying that rule quite so rigorously, and one of the ways of doing it might be by reference to general principles of international commerce. Don't forget, of course, in France, there is no review of substantive merits, never, no how. There's no Section 69. There is no way of submitting a substantive point to a court in the course of reviewing an arbitration except for international public policy. And that is not today's subject, but I can tell you it's very narrow indeed. Turning to the third aspect, once the arbitrators have in total freedom done whatever it is they wanted to do, what is the status of an award, an international award in French eyes? Here I will limit the question to the French approach towards enforcing international awards made outside France. The procedure itself starts on a completely without notice basis. You need to file either the original of the award and of the arbitration agreement or an authenticated copy, and you will get an initial enforcement order which will only be refused if your award is manifestly contrary to public policy. At a second stage, the other party, once the award with the enforcement order stamped on it has been served, is then at liberty to appeal against the enforcement order. Again, the topic today is not to go through all 5 of the heads of appeal, which in effect means the 5 heads for setting aside awards, although I'm very happy to answer any questions. The point is that there is one specificity of the French regime, which is it does not follow in every particular the grounds for setting aside, for resisting enforcement, under the New York Convention. And the most significant departure is that the French regime does not consider whether an award has been set aside by the courts of the seat. There are 2 bases for this in the New York Convention. One, of course, is if you look at the language of 5.1. 5.1 is the provision which begins, enforcement, recognition and enforcement of an award may also be refused if, and little e is the letter which says the award has been set aside by the courts at the place where it was made. So the better view, I would say at the moment, even though the French version, ironically enough, is prescriptive, the English version and the other language versions, I think it's Chinese and Russian, are all permissive. Awards may also be set aside if. Therefore, there is no requirement on the signatory, the courts of a signatory state. There's no obligation under the treaty to refuse enforcement for any of the grounds. It is permissive in the sense that the courts are allowed not to recognize if the award has any of the following features. So the second point is that under Article 7, there is a reservation in favor of more favorable national treatment, which in France, at any rate, is considered to apply both to arbitration agreements and to arbitration awards. And that is the, as it were, the treaty justification for the French regime. We don't care whether it's been set aside, where it was made. We will look at it afresh and come to our own determination as to whether it can be enforced or not under our 5 criteria. To end with a more ideological note, which is typically French, of course, the French courts have gone further than that. They have said that the underlying reason why they will not take note of what has happened to an award at the place where it was made is because, in effect, an award is not a product of the legal system of the country where the seat happens to be. Once an award has been made, it then has a vocation of being enforced wherever a court will agree to enforce it in accordance with international standards. So the French view is, just because an award's been made in England, that doesn't mean the English courts have a better right than anybody else to say what shall happen to it. And I'll give you an example, because it's created a fair amount of furore. The Putrabali case was an arbitration in which the first award was rendered. There was an appeal on a legal issue under Section 69. The award, the matter was remitted to the arbitrators so that they could enter a second award, which they did, which came to the opposite conclusion of the first. The winning party under the first award and losing under the second award was based in France. And you may consider that the behavior of that party was rather opportunistic. The party waited until the second award came out and then rushed to the courthouse with the first award, got an enforcement order, and that was appealed all the way up. The second award was also got an enforcement order to begin with, appealed all the way up. Conclusion, tough. We do not have to take account of the fact that the first award was set aside. That is not our concern. We issued an order for enforcement, and there were no grounds for setting it aside in France. Point 1. Point 2, the second award is inconsistent with the first, which is now res judicata in France, so you cannot enforce it. And that is consistent, and this is the high watermark to date of this rather ideological view. This is consistent with the idea, the notion, that an arbitration award is not a national judicial decision. It is an international decision. It has no particular vocation to be compliant with the laws of X or Y country, except for the purposes of enforcement. Obviously, the court that reviews the enforcement process has the last say. But subject to that, arbitration awards aren't judgments at all, they're not national at all, and we don't care what any particular foreign court has said about them. So that was my third salient feature, which is the most criticized one, it must be said. And I'd be very interested, Sir Anthony's views and your views, and why you think that's all very fine, or on the contrary, a completely irrational approach.
Sir Anthony Colman.
Thank you.
Thank you.
I have come without PowerPoints. I have also come, until about 2 minutes after I arrived here, without any knowledge at all about what Charles Kaplan was going to talk about. Accordingly, what I now say is an immediate, off-the-cuff reaction, in every real sense, to what he's said. And his presentation I found extremely interesting because my assumption was always that, apart from the Procedural case, the French courts, or at least, yes, the French courts, tended to play some greater part than now appears they do in the conduct of arbitrations in France. Most people here, if they are from the English system, will know that so far as the competence area is concerned, the giving effect to that concept in the English regime is a sort of partnership operation between, on the one hand, the arbitral tribunal, and on the other hand, the courts. I say a partnership because whereas the 1996 Arbitration Act recognizes that the competence principle should be deployed for the purposes of maximizing the jurisdiction of the arbitrators to determine their own substantive jurisdiction, nonetheless, it also gives effect to the concept that if you don't actually have a binding arbitration agreement, at the end of the day, the arbitrators appointed under it don't really have any jurisdiction at all. And this curious tension, which is somehow maintained by the Arbitration Act, is reflected in some really rather remarkable sections of the Act. Section 30 of the Arbitration Act makes it quite clear that unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction. That is to say, whether there's a valid arbitration agreement, whether the tribunal is properly constituted, and what matters have been submitted to arbitration in accordance with the arbitration agreement. Now, that's the starting point. And you might think that might be the end of the matter if the full range of the competence principle was to be applied. But this is not so, because the parties can, in certain circumstances, apply to the court. And one looks at the provisions of section 31, where we find that an objection that the arbitral tribunal lacks substantive jurisdiction at the outset of the proceedings must be raised by a party not later than the time he takes the first step in the proceedings to contest the merits of any matter in relation to which he challenges the tribunal's jurisdiction. And then we then find that in section 32, that the court may, on the application of a party to arbitral proceedings, upon notice to the other party, determine any question as to the substantive jurisdiction of the tribunal. But, and this is where one finds the limitation on the court's power, an application under that section isn't to be considered unless it's made with the agreement of all the parties to the arbitration, or it's made with the permission of the tribunal, and the court is satisfied that the determination of the question is likely to produce substantial savings in costs, that the application was made without delay, and that there's good reason why the matter should be determined by the court. So here we have a classic English compromise situation of a very, very practical approach to the intervention of the court. There are really substantial barriers to the court determining whether there is substantive jurisdiction. At the outset, in my experience, courts are loath to give to get involved in this issue because they do recognize that the competence principle ought, where possible, to be the dominant concept involved in the determination of substantive jurisdiction of arbitrators. Now, there is, I have to say, a really rather remarkable feature of the English regime with which I've been concerned on a number of occasions, namely the notorious Section 67 of the Arbitration Act. Now, what has happened is this. The competence principle has led to the arbitrators determining their own substantive jurisdiction. And they decide that they do have substantive jurisdiction. Well, we find in Section 67 this. A party to arbitral proceedings may, upon notice to the other party and to the tribunal, apply to the court, challenging any award of the arbitral tribunal as to its substantive jurisdiction, or B, for an order declaring an award made by the tribunal on the merits to be of no effect, in whole or in part, because the tribunal didn't have substantive jurisdiction. Now, here, this looks remarkably like a second bite of the cherry, and that's exactly what it is. You can get a very closely determined and detailed investigation by an arbitral tribunal into substantive jurisdiction. It decides either that it has it or it hasn't got it, and then if one party is dissatisfied with that, off it can go under Section 67 as of right, provided it does it in time, to challenge that determination. It doesn't have to show that the determination is probably wrong, as it does where an issue of law arises and Section 69 is in play. It doesn't have to show that there is a really substantial issue as to jurisdiction to be tried. It can have the whole thing reopened. It can adduce more evidence. There's a whole new hearing takes place. I conducted one hearing under Section 67 as to the jurisdiction of arbitrators, in which there were extremely difficult issues as to whether one of the parties was in fact bound by the agreement at all. That's usually the problem. Well, that in itself can involve very considerable issues of fact and, in this case, foreign law. There was expert evidence on, I think it was, Turkish or Bulgarian law as to the circumstances in which the doctrine of ostensible authority applied. When an agent could bind, and in what circumstances the agent could bind a so-called principal to an arbitration agreement. And before you know what's happened, you've got a huge trial on your hands, which may in fact determine the whole issue between the parties, because if you decide that there's no jurisdiction because there is no arbitration agreement, you may also have decided that there was no agreement between the parties at all, and therefore the claimant will necessarily fail. So that is a very odd quirk, and it's justified in the report of the committee which drafted this act by the principle, as I said at the beginning, that in fact, if there's no arbitration agreement, then even though the arbitrators may have, under the competence principle, the power to determine their own jurisdiction, if they don't have an arbitration agreement which underlies their appointment, there is no power. And so we get to the court determining the issue. Now, the other matters on which Charles spoke most interestingly are, first of all, the question of procedural and substantive law, and how an English court would regard an arbitration as conducted when the arbitrators have to decide what procedural law to apply and what substantive law to apply. When it comes to substantive law, English arbitrators are pretty strict. They apply, if England is the seat of the arbitration, they rigidly apply, by experience, English conflicts rules to determine what body of law governs the contract or the issue. And they don't apply lex mercatoria, they don't apply general principles of commercial law, except if the parties have agreed that those principles should be applied. And the system is very exact, very focused, and you look first at what the conflicts rules say, and if they say it's French law, the arbitrators treat the contract as governed by French law, and if the conflicts rules say another body of law, then that's the body of law that's applied. Procedural law, now this is really very different. You find in English arbitrations a vast spectrum of procedural approaches, ranging from the totally informal and passing through the general approach to international arbitration procedure with something sort of vaguely analogous to ICC arbitration procedure with memorials and this, that and the other, counter-memorials, through to a much more closely related procedure derived from English court procedure. I've encountered a wide range of arbitral procedures really determined by the arbitrators in conjunction with the parties. Currently, I'm sitting in an arbitration which is indistinguishable from an action in the commercial court. It's got everything that you would expect to find there. The formality of pleadings, the formality of disclosure of documents, the formality of witness statements, and everything, expert reports and so on. On the other hand, there are many arbitrations where a much more informal approach is taken. And I think it's down to the tribunal to give a lead to the parties, unless they insist to the contrary, having regard to the sort of issue which is likely to arise in the arbitration. English arbitrators are likely to be very pragmatic about this. If the issues are likely to be very simple, then the procedure can be very simple. If the issues are likely to verge on major issues of fraud, which will involve investigation of the detailed contacts between the parties, misrepresentation and so on, state of mind, then a much stricter approach to the procedure might be adopted. So flexibility is really the name of the game, and it's down, in accordance with the Arbitration Act, it's down to the arbitrators to determine the procedure in conjunction with the parties. If the parties want a particular procedure, the arbitrators can influence the parties, but at the end of the day, it's down to the arbitration tribunal to decide what's best for that particular case. I'm happy to say, my experience, they do that within a very broad range indeed. Now on the question of enforcement, again, the English courts really do stick very closely to the New York Convention exceptions. And unless the party that resists enforcement can bring itself within the exceptions, which are reproduced in Section 103 of the Arbitration Act, then the award will be enforced without argument. And I have found very few cases, going back during the time I've been commercial judge, when an attempt has been made to prevent the enforcement of an award by reference to one of the five, or as it is in Section 103, 6 circumstances in which an award may not be enforced under the New York Convention. Perhaps the most famous case, and one of the most difficult I've ever had to try, was the Westacre case, which raised the whole question of public policy as a reason for not enforcing an arbitration award. And the public policy in that case was whether, if there was independent evidence of corruption, if an award had been arrived at by Swiss arbitrators, in the face of that evidence, whether the English courts should enforce it if there was independent evidence of corruption. And in those days, which was before the European Anti-Corruption Convention, I decided to enforce, to give effect to the New York Convention exceptions. I'm not sure I would have arrived at the same decision today. Anyhow, there it is. There are big differences, and I hope I've simply outlined some of them.
Thank you.